considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership
All this
agreement.
can be argued before the arbitrator. Why should we entertain it at this
But
stage?
the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is based on arbitration agreement.
The long and short of the story is that it can be sent to the arbitral tribunal. Why should we?
Well, my set of pleadings in the commercials, it is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said that let the commercial remand order and saying
Yes.
that the commercial court should consider this.
Yes. Well, there could be parallel proceedings. Well, without looking into what was there before the arbitrator, the set of claims that were completely different. And my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counterclaim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plaint, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with the order.
Who are you actually? Who are you in the sense? Who is your client?
Well, my client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court in Tripura.
You are the dealer.
Yes.
You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminently from.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that dealership
agreement says, please consider our order. It directs the commercial court to consider their order, appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court could have been in the light of the dealership agreement.
All this,
but
this has to be looked at by the arbitrator. All this
arbitrator is deciding on the dealership agreement. That is for the respondent. That is that is the claim of the respondent against me. My claim against the respondent is completely different, and my suit is a prior.
You heard your point. No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order, appointing an arbitrator. That's all.
But this is where I join my issue, my lord. Just one way.
I heard you now. I think we've made access clear.
To say, my lord, that the Calcutta.
Lordship, in item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the mine in dispute was transferred to respondent number 1 because it was transferred without following the provisions of law, and according to me, it is void.
Before that, you have to answer why we should condone the delay of 170 days in filing the SLP.
My Lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court
was on the ground of delay. Yes, thank you. Item 16.
My Lordship, may kindly consider as soon as we got the matter, we got it filed. My Lordship, may kindly consider, because the petitioners are also very not very poor. My Lordship,
they have been in possession of the mine for the last 50 years.
But my Lordship, that transfer was illegal. My Lordship, that was
not a case for injunction. The High Court says that somebody who is in possession of a mine for 50 years, they can't be now injuncted like this. So, though we are dismissing, we can say this. We can even say this. Though there's a delay of 170 days in filing the special petition, we have also examined the correctness of the impugned order on merits and find no reason to interfere with the order. The special petition is accordingly dismissed both on the ground of delay and on merits.
My Lordship, one last.
That's better. So that item 16.
Blacklisted issuing any show cause notice and contrary to the terms of the tender itself, if my draw your lordship's attention to page 98.
The cancellation may be. Learned Senior Counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted for a period of 3 years from participating in the works of in the contracts of the municipal corporation without a notice to show cause being issued. Issue notice confined to the above aspect,
Lordship.
returnable on Khabar.
Lord, we are only requesting for a stay, my Lord, because I won't be in a position to participate in any of the auctions, my Lord.
We'll make a short notice.
Lordship.
Oh, I see.
Lordship.
It's a due process.
Obliged.
17 number of petitions have been disposed of by the High Court. All the matters are not listed today. They pray for a 1 week time.
But there's a 174 delay, 174-day delay here.
No, as far as the first matter is concerned, there is 74. As per my-
174-day delay.
But in other matters, it is not there, madam. In other,
174.
yes, but in other matters, the delay is not too much, madam. Kindly see, madam. In some matters, it is on-
17. How many matters are there on 17?
in total, there are 8 matters, 7 matters, madam. All the matters are not listed today, madam. It will be taken after a week, madam.
You can get your other matters. We'll dismiss this on the ground of
No,
delay.
madam, kindly see, my lord. At the,
How can the state keep on saying that, look, there are other matters where there is no delay, therefore condone?
I'm not saying, I'm not saying, madam, kindly take up all the matters together, madam, because therefore delay part is concerned.
We will keep those other matters. We'll dismiss this on limitation.
Madam, kindly take up this.
Limitation applies equally to everybody, and I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit
My lord, as per my
And,
report, it is
allow-
74, my lord.
and it's serial number 37, there's 74 days delay. We'll look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of
No,
limitation.
my lord, I'm just praying that we'll take, because on the technical ground, kindly see, my lord. Technical ground, my lord, they have to more than 3 or 4 crore rupees, my lord, kindly see. They have to pay more than 3 or 4 crore rupees, my lord, kindly see.
7 reaches. We'll see what the
But
merits.
all
of
the
that-
matters are not listed today, my lord. If I'm saying, if you've taken after a week, my lord, all the matters, my lord.
How many are there?
In total, there are 8 matters, my lord, only 3 or,
Like, give the numbers
yes,
to the
I will give the numbers, my lord.
list together with so and so.
On Friday, my lord, next Friday. In the meantime, if there is defect, I will give the defect all them.
Item 18,
But it's on Friday, madam.
next Friday.
Good, very clear.
This is a really piquant and unjust situation where I can't appoint an arbitrator. The matter is under litigation. Their appeal has been remanded by this honorable court to the High Court because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
The arbitration award was set aside by the single judge.
Section 34 judge.
I think Justice Dhanuka's judgment.
That's right.
We had dealt with this.
Justice Baldota's judgment.
Justice Baldota's judgment. There was a similar case which just came a few days back where there was the division bench set aside Justice Baldota's award on the
ground of perversity.
on the ground. What happened in the single judge?
No, thereafter, after the award was set aside on the ground of perversity, they filed a section 37 application, which was dismissed as non-maintainable. Then they came to this honorable court. This honorable court found the appeal was maintainable and therefore remanded it back
To the division bench.
to the division bench, and that matter is still pending, though we have made requests, and this honorable court had also directed expedition. That matter is still pending. When therefore this matter is still pending litigation, and the situation is that a perverse award against me has been set aside, behind my back, 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023, where when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all, my lords.
Of course,
That was the
because,
initial payment.
If a construction has taken place
With
and
respect,
now you have invested about 22 lakhs, the
he
High
has
Court
paid
seems
8
to
lakhs,
be-
my lords. The respondent number 3 has paid 8 lakhs. It can't go by the
High Court
figures.
seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being
With
rehabilitated.
respect, my lords, with respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration, right? The award in the arbitration. What was the actual award in the arbitration which was set aside?
The award was that I'm not entitled to specific performance and I'm not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large, and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get impleaded in that appeal. And I can't appoint a Section 11. Award was that my claim was dismissed. My claim was against his reneging on the 2005
So your claim
MOU.
for essentially for specific performance
Lordship.
or implementation of the MOU, that was rejected by the arbitrator. The single judge set aside the award and just set aside the award simpliciter.
simpliciter on the ground of perversity, but set it aside.
Right.
Therefore, fresh arbitration has to start. In any case, a fresh arbitration has to start. Immediately after the appeal was dismissed by the Bombay High Court, I filed a Section 11 application for fresh appointment of an arbitrator.
The appeal is by the other side, of course.
The
before-
appeal by the other side. When that appeal was dismissed, I filed a Section 11 application, but then this honorable court remanded the matter back to the High Court. So
even
logically,
even assuming that ultimately in the appeal, the award is affirmed, you still have recourse to a fresh Section 11.
and that is not being allowed by the impugned judgment. That is what is not being
They have
allowed.
created third-party rights in the meantime.
Lordships, and they have created third-party rights. And well, a fault is being found with me.
We'll have to consider this because you have been non-suited even on your.
Lordship,
Section
please.
11. Section 9 or something, we may or may not be with you. but-
Section 9 minutes, my request is this. If behind my back, this agreement is entered into
So
and
Ramchandran,
not disclosed to the court, not disclosed to the court.
you're also a very big builder in Mumbai.
Lordship, please.
There's nothing behind your back. You see the whole construction coming up and you said a big building is
I
coming back.
happen
nothing
to,
is behind
I
your
happen to
back.
see it because I was passing that way. I was passing that way. I'm not traveling on all the roads of Bombay every day, minutes. I'm not traveling on all the roads of Bombay.
This is
every
not
day.
by, this
On
explanation
Section
is
9,
not
minutes,
there.
if your lordships are in
But on
issuing
Section
notice,
11, perhaps, you have a point that at least your remedy under 11 can be kept open, depending upon the outcome of that appeal. Perhaps, we'll see. We'll
on
see.
Section 9, my only limited prayer is this,
We'll-
minutes,
we'll-
as your lordships issue notice, let them not create third-party rights in favor of buyers. Let them not
Although
create.
we are issuing notice, we'll make a short notice.
Let's
We don't want to issue an interim order without hearing them. Serve Dusty and come. We'll just rise, members of the bar will rise because our distinguished colleagues from Brazil have to go around the court and look at the facility. We just rise for 2 minutes and
Before the learned visitor, minutes, rises with your lordships, I thought an anecdote, seeing your lordships encouraging a junior a few matters back. 48 years ago, minutes, in court number 2, Senior Justice Chandrachud was the presiding judge, and a 2-month-old lawyer, namely yours truly, was appearing before him, shaking with nervousness. And Senior Justice Chandrachud looked at the appearance slip and said, yes, Mr. Ramachandran, which gave me such confidence that I was able to argue a useless matter for 5 or 10 minutes. So I was reminded of that day, Milord. Sorry, Your Lordship.
Thank you, Mr. Ramsar.
But can I request, Milord, for Dusty in addition, Milord, so that it
I
comes
just
in
told-
2 weeks,
I
Milord?
just told the court master it will be served dusty and after 2 weeks.
And no third party rights, Milord, in the meantime.
That's why we are giving you 2 weeks. Thank you.
Lordship, please.
Parmeshwar, which are the states which have not implemented our judgment?
I just circulated a note here. I have a note, my lords. I have got a detailed note. Yes,
You have the note here?
yes. What is this kind of take the note?
Mr. Solicitor, that is the updated position you have now of who has,
Yes, I have the updated position till yesterday night. Then till yesterday night, we were served affidavits and compliance. But I just wanted to bring to your lordship notice, this is the 6th or 7th time your lordships are asking them to pay up allowances and pay, my lords. If your lordships kindly see the major defaulters, let me just point out from page 6 onwards. My lords, a number of high courts have deducted TDS on allowances, my lords, so that issue I'll come to. But if your lordships,
because allowances, you can't deduct
it is
TDS.
at all protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. If your lordships kindly see from page 6, Allahabad. Page 6 minutes. So lordship sees, so far as Allahabad is concerned, my lords, there is more or less compliance. I shouldn't take, I think there are minor difficulties which will get ironed out, my lords. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I have marked it in
Substantial?
non-compliance. Your lordship sees the last two columns. So far as payment of revised allowances are concerned and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received.
Fixed, my lords, may just for payment of arrears. Right?
Possibly, I just wanted to bring to your lordship's attention. The 7th time your lordships are extending time. Repeatedly, your lordships have recounted all those orders in the first 3 parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own.
15th August, 15th August.
15th August. All states, my lords,
A note has been submitted by Mr. K. Parmeshwar, then the mic is curious, indicating the status of compliance with the orders passed by this court on
my lords, 3 orders, my lords, 27/7/2022.
27 July 2022
to
30 July 2023,
19th May 23 and 4th January 24.
19 May 2023
and 4th January 24.
Then there's 23rd November also, no?
That is only for extension, my lords. Your lordships again for the substantial order, your lordships.
And 4th January 2024.
24.
Full stop. Those seven opportunities, 7, right, have been granted by this court to the states to comply. It appears that full compliance has not been effected and several states are in default. Full stop. The note highlights the states in default. And we will deal with them. Full stop. They are dealt with CRETIM, Andhra Pradesh. The Leonard Standing Council. Leonard Standing Council. Standing Council. Ms. Prerna Singh, appearing for the state of Andhra Pradesh, states that she has instructions to the effect that the payments which were to be made to the judicial officers have been made.
Whatever could be uploaded has been made.
Whatever could be uploaded.
Portal. There is a portal for the uploading of bills of arrears, which is the main, if my lords will see the last column, that is the main non-compliance that has been attributed to us.
Ms. Prerna Singh, Learned Standing Council for the state of Andhra Pradesh, Learned Council for the state of Andhra Pradesh states that the portal through which bills were to be uploaded that payments have been made to the extent to which bills were uploaded on the portal, on the web portal, which was opened for that purpose. Full stop. Should we say, Mr. Parmeshwar, that this may be verified?
There's clearly non-compliance because judicial officer spoke to me yesterday night. Number of judicial, the All India Judges Association is also here, my lords. There is no doubt, my lords, most states have been lackadaisical.
All right. We will say that on the other hand, both the amicus curiae and
All India.
yes, and the All India Judges Association, which is represented in these proceedings, have categorically stated that that full compliance has not been effected. Full stop. We direct that a meeting be held meeting be held by Monday between the Registrar General of the High Court of Andhra Pradesh, the Chief Secretary.
Would your lordship then direct that committee to meet? Your lordships had institutionalized it, and that committee, all of them, all the relevant people are part of that committee.
Be convened by the committee appointed by this court in its order dated
4th January
4th January 2024.
SCDJ.
What do we call it?
CSCDJ.
The CSCDJ. Within preferably on Tuesday, we say to have a little time. Preferably on Tuesday next, so that in case compliance is still to be effected, it is completed no later than by 15 August 2015. Full stop. A compliance affidavit shall be first shared with the CSCDJ and thereafter filed before this court, indicating compliance, failing which this court will be constrained to adopt contempt proceeding against the officers of the state if full compliance has not been effected. Then,
then Bombay, my lords. If your lordship sees Bombay at page 8, my lords, most of it is in substantial compliance except for the part so far as TDS is concerned. On TDS, your lordships will pass an omnibus order on all high courts, my lords. Would your lordships only see, this is unfortunately, my lords, your lordships will see, if your lordships, the second last column, what they've been doing is many state governments have again tinkered with your lordship's order on allowances. After your lordship's order, there's no question of the state governments now saying that this is not permissible under our rules. We will not allow it. Mobile handsets can't be. Your lordships, remember during the hearing also this question on mobile handsets, ACs,
that we'll deal with separately.
Furniture, ACs. So an omnibus order on the count that there's no question of now deviation from your lordships.
That we'll deal with.
So far as Bombay is concerned, only this, because they have now said we'll take a call on mobile handsets and AC and furniture.
That we will.
Otherwise, there has been substantial compliance so far as Bombay is concerned. They have taken effective steps.
Which are the states which are not compliant?
Calcutta.
West
Bengal has moved an IF for extension of time with us.
We'll give you a time till 15th of August to comply by 15th of August.
I'm only requesting some more time. It was 15th of August. I don't want to come back, seek further time.
It has to be, because 7 opportunities have been granted to us. All states have paid. I mean, how can West Bengal say we will not? Then
It's not that-
you say that, look, then you can sit at home, will not take any work from judicial officers. They are all working there.
May I say this?
Well,
But it's
one
only-
minute.
May I, Manoj? It's only pertaining to arrears, Manoj. Rest of the things have been implemented pertaining to the arrears.
Telangana state, my
That we are
lord.
not compliant, because in the Amicus report, it says partially compliant.
How much have you paid?
They will not, none of the states are very smart. None of them will say how many judicial officers are there. They will say we have complied.
Because once we
No
come
details
clear,
of-
we shall come clear on this, Manoj, by filing
State of-
everything, Manoj. Because
I just for giving specific. May I just
State of West Bengal, there has been non-compliance by the state of West Bengal with the orders of this court. Full stop. The time has been, 1 year's time is sought for effecting compliance, which is unreasonable. Full stop. We grant time for full compliance till 15 August 2024. We'll keep the matter for reporting compliance on 20 August, we'll keep the matter. We extend time for compliance until 20 August 2024. Full stop. The proceeding shall be listed on 23 August 2024, on which date both the Chief Secretary and the Finance Secretary for the state of West Bengal shall remain present before this court
Great.
with affidavits indicating compliance.
All states, just bring to your lordship's notice,
Just allow me.
all state government and union government wanted with the 16, that was 7th pay commission. We are on the threshold of the next pay commission, 2026, and yet our judicial officers after 8 years, 9 years haven't received it. It's not as if it's a separate case for judicial officers. Most of these recommendations are at par with state government and union officers.
We are constrained to pass the above order. We are usually circumspect in directing the personal presence of the officers of the state. Full stop. However, this is a situation where the officers, the bureaucracy has received the revision of their pay scales and other allowances with effect from 1 January 2016. Full stop. Judicial officers are yet to receive the revision, the revised pay scales and allowances. So the arrears which are due to them in terms of the SNJPC, so 8 years have elapsed. Full stop. Despite, as we have already noted, despite sufficient opportunities, there has been non-compliance. Full stop. It is in this backdrop that we have been compelled to pass the above order. So then,
My lord, instead of
I'll just take.
bureaucracy, your lordships may consider administrative officers in the executive.
bureaucracy, administrative officers in the executive.
But it's a better, but that's
Better.
Let's take
the
this, if Manoj permit me. Manoj, just one thing, Manoj may not say that state of West Bengal has not complied. Manoj may kindly say partially complied, as the amicus has stated, because it seems that we have.
But you have not told us how much you have paid. You tell us how much you have paid, then we would have
I'll
recorded.
come back on this and just.
Anyway, you now, you figured, all right, which is the next one now?
Just only one thing, if just in case we are not complying by 28th, then Manoj may require the presence of.
Now, they have to remain present with an affidavit of compliance. Otherwise, we'll send them marching from here. Yes.
Plus, Chhattisgarh also concern is the allowances, but if your lordship, 1 minute, tax, my lord said there will be an.
Tax will pass a separate order.
Again, the same thing in Chhattisgarh also, they will say we are considering whether we should grant those allowances. I don't understand those GOs, with all due respect, Manoj. After there is a Supreme Court judgment, the subject matter of all those GOs mentions the Supreme Court judgment of 4th January 24 and then says we will now consider whether we must grant those allowances.
Where is that in your note?
If your lordships kindly see page 10, Chhattisgarh Millets, your lordships will see committee is considering upon the mode of payment of concurrent charge allowance. State has issued geo-dated so-and-so sanctioning increments on acquiring higher qualification, but no date has been mentioned. All that is clear in your lordship's judgment. There's no question of now saying that we will deviate from your lordship's judgment. And your lordship will see this.
State of Chhattisgarh, comma, the GO issued by the state indicates that the committee is considering the mode of payment of the concurrent charges allowance, correct? The concurrent charges allowance. The state has issued a GO sanctioning the increments on acquiring higher education qualification, but no date has been mentioned for effecting compliance.
And out of 20, only 11 have been sanctioned.
And full stop, out of 20
allowances,
allowances, only 11 allowances have been sanctioned. Full stop. The state, the conduct of the state of Chhattisgarh is plainly unacceptable. Full stop. Despite 7 opportunities, 7 is there also, no?
Everywhere, my lord.
Despite 7 opportunities, the judgments of this court have not been complied with. We direct the personal presence of the Chief Secretary and the Finance Secretary of the state of Chhattisgarh before this court on 20 August 2024. 20 August bola tha na?
23rd, my lord.
23 August 2024, together with affidavits of compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. All right, that's Chhattisgarh. Then full compliance by the 23rd. Yes, and the Chief Secretary and Finance Secretary have to be personally present in this court on that day. Now we are not going to say that if you comply with, then you need not be present, because then they'll not comply with. Only if we now direct presence that they will comply with. We now know how to extract compliance with the order. Yes. We're not going to send them to jail if they comply, but they have to be present here and tell us that they have complied. Nothing doing now. Yes. Which is the next?
Delhi, my lords, page 12, no allowances, no arrears of allowances have been paid.
Delhi.
No allowances, no arrears of allowances. Last 2 column.
The NCTD, the government of NCTD has not complied with the orders passed by this court. Full stop. No case for extension has been made out. Full stop. We therefore direct full compliance with the orders of this court by 14 August, by 20 August 2023. The Chief Secretary and the Finance Secretary of GNCTD shall remain personally present before this court on 23 August 2023, together with affidavits of compliance for the purpose of reporting compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. Then,
Milords, Assam, no compliance. They have moved an IA for extension saying citing floods because there was no
Assam?
floods in the year of.
Filed an affidavit, Lordship. Lordship, we have issued the notification. So far as 14 heads are concerned, Lordship, we have issued the notification, the report, because it came later, Lordship. That was the only thing, Lordship. The time, Lordship, that is being taken, Lordship, is we are really, Lordship, now facing disaster.
the council appearing on behalf of the state of Assam
Disaster situation.
states that a notification has now been issued for the payment of 14 allowances.
14 allowances in the
Full stop.
Not 7, Lordship, 6. Lordship said
7.
There has to be full compliance with the orders of this court. Full stop. This court is not inclined to grant any further extension of time or exemption to the state. Full stop. The Chief Secretary and the Finance Secretary of the state of Assam shall remain personally present before this court on 23. So, ऊपर जो लिखा था ना 20th August and 23 August. Same order.
Lordship, our situation is a bit critical, Lordship, is because of disaster situation.
Yes, these are people who are
Lordship,
working. These are people who are working in service.
Yes,
you have to pay them now, and just
Lordship,
7 opportunities. No?
Lordship, may I just submit, Lordship? Lordship has given time to the other state till 15th of August.
20th August we have given you. We have given you time until 20th of August, paid by 20th of August, and asked the Chief Secretary and Finance Secretary to be in court on the 23rd of August to report that they have complied. So that then we will we'll put an end to the matter.
That may be exempted, Lordship.
No,
We
no.
are in a genuine situation.
Then I don't know what will happen.
Different
Then there will be another application for extension. Once we say this, the money will come.
Lordship, we are in a peculiar disaster situation, Lordship. We are facing it, Lordship, in the state, Lordship, everyone is.
How much is the amount that you have to pay?
Lordship, I suppose it is more than 100 crores, Lordship, more than, it will be for a state like Northeast, and we are facing floods, Lordship. It is the third round of floods. It is the third round of
Ask
floods.
the government. ask the government of India to pay you. They'll pay you from some other head. Yes.
Lordship,
Which is other.
Lordship, our case, Lordship may kindly consider.
No state.
The other states will not come out with this situation, Lordship.
No.
Our situation is a bit critical, Lordship.
We'll not do anything like
Lordship,
that.
consider it on the next day, Lordship, on 23rd.
Still to remain, we'll see if.
Lordship, 23rd, if we don't show any progress, Lordship, kindly consider.
On the 23rd, if you are not able to pay, let the Chief Secretary and Finance Secretary come here and tell us why you can't pay. We'll consider your request. But they must remain present.
Lordship, that's what, Lordship, I was only requesting, Lordship. Kindly pass that order on 23rd, Lordship, if we don't do.
No.
Lordship, we are in a situation, Lordship.
No.
We are in a critical situation, Lordship.
Tell us
That's why
from when did your
Otherwise, I would not have pressed it, Lordship.
Tell us when, from what date did you revise the pay scales of your administrative officers?
That we have complied, Lordship.
From which day?
So far as the administrative officers.
Huh.
So far as the SNJPC, Lordship, we have complied with everything, Lordship.
No.
That I can't offhand tell, Lordship, from which
When
date.
have they got
Lordship. I'll take
revisions? We'll
instructions.
tell you, 1st of January 2016.
Lordship, we have complied with every direction of the SNJPC, Lordship. We have complied with
The
everything.
point, we'll pay the state civil service officers. Judicial officers are not our,
Lordship, I
they're
am not
not
making
our.
a legal argument, Lordship. I am not making a legal,
Not at all.
it's on
Now we have-
a different criteria, Lordship. It's
Now
only
what
on
about
this.
who else, Mr. Parmeshwar?
My lord, so far as Guwahati High Court is concerned, my lord, Arunachal, Nagaland and Mizoram, my lords, notifications are there, but release of funds is, according to the last affidavits, not comes. So your lordships may direct the same direction so far as Arunachal, Nagaland and Mizoram.
The same direction shall apply to the states of Arunachal, Nagaland and Mizoram.
Mizoram.
Then,
Lordship, I am here for the state of Nagaland. All the information has been collated, is scrutinized, is just pending with the finance department, your lordship. There has been compliance. We've accepted all the allowances, your lordship.
let's apply.
So kindly give us time and your lordship may not,
Time till 20th of August.
insofar as the presence of the chief secretary and the
We have to
finance-
now, we have to secure presence.
because there has been substantial compliance, it's
Yes.
just the dispersal of funds, your lordship.
The compliant come here, come visit Delhi once, yes.
My lords, Gujarat, my lords, I am now told there is substantial compliance except TDS.
TDS, that we'll just pass an omnibus order.
Himachal Pradesh, my lords, the affidavit doesn't give us any information, fortunately. So far as,
What is the position in Himachal?
even they.
State of Himachal Pradesh में ऐसा लिखिए, the Chief Secretary and Finance Secretary of the State of Himachal Pradesh shall file a joint affidavit indicating compliance. Full stop. Since as of date, who's appearing for the State of Himachal Pradesh? Where is he? Who's appearing for the state of Himachal Pradesh? Learned Counsel for the state of Himachal Pradesh is absent when the case was taken up. Is taken up. Full stop. The Chief Secretary and Finance Secretary of the state of Himachal Pradesh shall personally remain present. Will be same order, huh? Let them come here. Yes. Then
My lords, Jammu, Kashmir and Ladakh, my lords, no money is paid. My lords.
Jammu and Kashmir and Ladakh, same order as.
Complete non-compliant.
as
My lord,
Assam.
for UT of Ladakh, may I assist your lords in case of the UT of Ladakh, my lord?
Yes.
My lord, in case of UT of Ladakh, all the funds are available with the two district judges, my lords, and the two district judges are the drawing and dispersing officers. The funds have been provided, my lords. The dispersal is with the learned district judges, my lords. My lords may have my compliance affidavit.
Regards the Union Territory of Ladakh, Mr. Piyush Beriwal, right?
Yes, my lords.
Learned Counsel states that the two district judges are drawing and disbursing officers, and the funds have been placed at their disposal.
Yes, my lords. My lords, we have also filed this via an affidavit, my lords.
All right. So Ladakh ke liye don't pass any order of presence.
Much obliged, my lords.
Jharkhand also same thing, my lords, no information on arrears of allowances.
Jharkhand. Have payments been completed? Have you paid all the 20 allowances? Then same order for Jharkhand. Ask the Chief Secretary and Finance Secretary to remain present. Time until 20th. Yes, then
Karnataka is not a concern, my lords. Karnataka is not concerned. Kerala, my lords, not paid. They have moved an application for extension. They have not.
Kerala, pay. That's all right. You ask the Chief Secretary and Finance Secretary to remain present. Kerala, the same order. Compliance by 20th, personal presence on the 23rd. 20th of August and personal presence on the 23rd. Yes.
Mallards, Madhya Pradesh also same thing, Mallards. SOP has been made by the committee, your lordships constituted, but no disbursal.
Madhya Pradesh is the same. Madhya Pradesh, same order. Then
Tamil Nadu, my lords, not a single paisa.
Tamil Nadu,
grave defaulter.
same order.
Manipur had a problem, my lords, they moved an IA over.
With respect to the pay and pension, everything has been paid. The allowances, they have been approved. The prospective payment of the allowances have started, and I have got a pay slip from the respective DDOs also. Because with respect to the areas of pay, that is the only problem that we have. Unless we were seeking a little bit of more time for
How much do you have to pay?
This is about 24 crores. And
the
state is running into some deficit.
Yeah,
So
get it from the Union of India. Same order for Manipur. Yeah.
can it be a little
20th August, now 20th August. It's uniform for everybody, yes.
Meghalaya also, my lords.
Meghalaya,
Same thing.
same order, Meghalaya.
My lords, Odisha, my lords, is
You're from Meghalaya?
I have instructions just now that the status was previous to end of financial year.
So 20th August.
My lords.
20th August, ask the Chief Secretary.
My lords, I'll file an affidavit which has been.
If you have paid, mention the matter earlier and tell us we have paid, we will exempt your Chief Secretary. But otherwise, we have to be present here.
I'll mention the matter.
But so far as Odisha is concerned, my lords, 6 allowances they decided not to do.
Orissa,
And so far as the arrears is concerned, they themselves decided that they will pay it over 6 or 7 installments.
Same order.
Lord, as far as the
Ek order likh lijiye. 6 allowances have yet to be paid.
Lord, as far as state of Odisha is concerned, the resolution of the finance department has come in on the 16th of March 2024, and the law and the home department have submitted the proposal in the ensuing session for release of the funds in the Odisha legislature. That's the instructions which I have.
Learned Council for the state of Orissa states that the
resolution of the finance department has been issued on 16/3/2024.
That the resolution of the finance department was issued on 16 March 24.
And the law and home department has submitted the proposal for making the budget provision in the ensuing.
And the law and home department have submitted proposals for ensuring payment.
The budget provision.
For making a budget provision in the ensuing budget session.
Ensuing Odisha.
20th August, we are keeping
well.
compliance and ask the Chief Secretary and Finance Secretary to remain present.
Very well, very great.
Yes.
And so far as Patna is concerned with it, I am now told, yesterday evening I received a note saying that they have started disbursal of all the allowances. But the last affidavit which was filed, my lord, said that allowances have not been paid.
All right. Then, yes, then.
It's Punjab and Haryana High Court, my lords, again, the committee filed an affidavit.
Bihar, as a Learned Council for the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Judiciary Department, right? And and the payments are being made in full compliance with the order of this court. What's up? Then
Punjab and Haryana, my lords, allowances arrears have not been complied with, and allowances future payments are partial compliance. Your lordship, see the last 2 columns.
So same order for state of Punjab, ऐसा लिख लीजिए. Same order, we'll say full compliance. We should.
There's an issue with respect to state of Punjab and Haryana. The matter is pending before the full bench of the High Court. The allowances, that's why they were not released. The state has complied with it. Your lordship may see the note as well. There's an SLP pending before this court, pursuant to which the High Court has held its hand and not released and not granted this approval.
Which allowance? Which allowance?
So except for super
Other than
time.
that, we have been done, your lordship, for the state of Punjab. For the state of Punjab, we have done, your lordship. Only that matter remains pending before the High Court. Page 116.
All right, state of Punjab के लिए ऐसा लिख लिया. Where is page Punjab is
Page
20.
1168, your lordship. of the-
That's in respect of, that's not allowances, that's only selecting time and super scale. That's litigated between the judicial officers, therefore that full bit I've examined.
What about the allowances? Have you paid the allowances?
Your lordship, we'll place that on record, your lordship.
Sorry?
We have released the allowances, 11th April 23, your lordship.
We pass the same order. If you have, come back to us, file an IA before the next date of listing. We will, and give it to Mr. Parmeshwar. We'll verify it. We'll delete the requirement of the presence of your chief
Sir,
secretary.
but to that effect, your lordship.
So you first ensure that the full payment is made, file an affidavit, give it to Mr. Parmeshwar, come here and mention it. We will exempt appearance. You know?
Whereas Rajasthan, same order as the others. No information has been provided to this court in the complaint.
Rajasthan? All right. Anybody else?
But I'm sorry, my lord, I was just trying to say something, but I was not unmuted, unmuted, my lord.
For Mr. Badri?
For Delhi, my lord.
Yes, for Delhi.
Problem for Delhi, yes, my lord. We are waiting for the approval of the central government because we have we can make payment only once the central government approves.
No, we are not concerned with that. You sort it out with the central government. We want payment to be made. Yes.
Let's in that Punjab and Haryana, the other order continues.
Central government has permission. This.
Haryana. I dealt it as high courts, because the Haryana, the other orders continue because they have not paid up the allowances.
Haryana the same order will continue.
And Punjab this order.
Punjab का हमने एक order pass किया था.
Telangana state, my lord.
Rajasthan,
Consider
Sikkim
this
and
that
Tripura
central government has filed review petition.
Punjab and Haryana, we have passed the same order. Punjab, Haryana, the same order of personal presence.
Right.
Provided if they come back here and file an IA saying that we have paid, then you can tell us. We will. You can mention, Parmeshwar, that these states have been. You can come and mention to that.
So that's so far as Rajasthan, Sikkim, Tripura, and Uttarakhand concerned, my lords. Rajasthan, Sikkim, and Tripura the same order. Allowances have not been paid.
Rajasthan, Sikkim, and Tripura same order. And
Telangana has complied. Uttarakhand the only issue is TDS.
All right.
Plus on TDS, I just one
As for Sikkim, may I make one submission, my lord? May I request for a similar indulgence as the previous council? Once I file the updated status of allowances, may I make a request for exemption for appearance, as my lords have permitted the previous councils for other states? Because I'll get the updated status and ensure that the allowances are paid.
Let them be here. Yeah.
Yes,
let them hear.
Similar
Let them appear. Yes.
Sorry. So far as TDS is concerned, would you want to pass an omnibus order saying wherever the exemptions are offered under the Income Tax Act, so far as allowances are concerned, no TDS should be cut because there's no point in going allowances one by one.
Wherever exemptions are wherever exemptions are available under the provisions of the Income Tax Act 1961, from the deduction of TDS on allowances, the state government shall ensure that no deduction of TDS is made.
And wherever deducted, my lords will give them time till September to return that because then this is complete deductions. It'll have to go back because this is 1 minute. The state government is deducted so that
wherever the state governments have wrongly deducted the TDS, they shall refund the amount to the judicial officers on or before 15 September 2024, with liberty reserved to them to pursue their claim before the department.
I have with my note which I have circulated, I have put an appendix A where I have encapsulated under the Income Tax Act which all allowances that are part of the SNJP are exempted under the Income Tax Act. So my lords, if something like that can happen, and I've also annexed along with my note the payment slips of the judicial.
All right, what we'll do is that we'll take up, we have covered the states, right? On the issue of TDS ka baad mein dekhte hain. We'll keep it on Monday. Just look at what she has said, the allowance to examine.
My only fear was that.
Can you serve the central government council so that we can then deal with TDS on that? Just ask Mr. Venkatraman to remain present here on Monday. You can tell him what the issue is so that then we can clarify it.
Just housekeeping, sorry.
Yes.
So then all those contents in the IS can be disposed of unnecessarily.
For Telangana state, my lord, no complaints. For Telangana state.
Where are they?
Page 26 of my.
Yes, there are eight contempt petitions. Yes. Page 26 ko, serial numbers 1 to 6 IAs stand disposed of.
Similarly, my lord, those 8 orders dated 22, of them merged in those contempt petitions.
Telangana State, my lord. Telangana State.
57, there are a number of IAs and petitions for intervention, including at least prior to your lordship. Those also can go. Every time.
All serial number 1 to 17? Serial number 1 to 17 का जो page 27 और 28 को है, वो भी disclosed.
Your lordships may mention one IA.
So what we'll do is,
Your lordship on IA. Lordship. With your lordship's permission, my lords, may I?
well, in the afternoon today, the Neet had.
I'll just log in.
Matters on Monday, including Neet also will take up on Monday.
May I have your lordship's time for just half a minute? Can I have the attention of the court for just half a minute?
So we'll take up Neet tomorrow first on board, and then we'll proceed. Mr.
May I have your lordship's attention for a minute?
That's serial number.
38, my lord.
38, kal rakh do. 38.
Very obliged.
Lordship, my lords, if 38 can be on Monday, my lords, we need take instruction and we'll place something on record also, my lords.
Mr. Ranjit Kumar, yesterday the solicitor was also saying that he will require a little time on Monday.
But the problem is this, not every day one order is being passed. Again, today has been passed.
Place that on record, my lord. Nothing worse has been passed, my lord.
What is being happening is, Virat, as I mentioned yesterday, not about curiosity, what happened. 9 July, they said, no, that order is withdrawn. They're not 10th again, yes.
Can we take it up on Monday?